A primer on living trust. All you need to know in 10 questions and answers. Living trusts are a popular way to avoid probate. Check out this video to learn what they are and how to use them effectively. Most people want to leave as much of their money to their children or other heirs as possible and want to make sure a large portion of those funds doesn't end up in probate lawyers' pockets. That's where living trusts come in. They can help in sidestepping probate and probate fees. Probate involves inventorying and evaluating the property, paying debts and taxes, and distributing the remainder of the property according to the will. When you establish a living trust, your surviving family members can transfer your property quickly and easily without probate. Welcome back, folks, to another edition of Sweetie Kiwi. How are you doing today? I hope you are doing fantastic. I'm doing marvelous, if you were to ask me. If you are doing as terrific as I am, go grab a cup of coffee or tea or vodka and let's roll. Today, I want to talk to you about living trust, and I want to give you 10 questions and answers so you can figure out exactly what a living trust is. Let's get right into it. What is a living trust? So a trust is essentially an arrangement under which one person, called a trustee, holds legal title to property for another person called a beneficiary. So you have trustee, beneficiary. You have a trustee who holds legal title to assets for the beneficiary. So you can be the trustee of your own living trust, keeping full control over all property held in the trust. A living trust, sometimes called inter vivos trust, is simply a trust you create while you are alive, rather than one that is created at your death. Hence the word living. So different kinds of living trusts can help you avoid probate, reduce estate taxes, or set up long-term property management. Now, when it comes to naming yourself as a trustee, it's always very important. A lot of legal experts advise clients to have a successor trustee. In other words, someone who will come as a backup trustee after you're gone, after you pass away. So think about that. How do living trusts avoid probate? That's the second question here. A lot of Americans, I would say 90% of Americans, go into the living trust process to avoid probate. So a revocable living trust, unlike a will, offers a speedy, private, probate-free way to transfer one's property after death. Even though a living trust is not entirely a complete substitute for a will, because, for instance, it doesn't allow you to name a guardian for a child, it is still a more efficient way to transfer property at death, especially what I call large ticket items. I'm talking about house. If you have a house, or you have significant interest in business, whether in an LLC or a partnership, or you hold significant financial assets, talking about stock, bonds, ETFs, commodities, and so on and so forth. So property you transfer into a living trust before your death never goes through probate. The successor trustee, this is the person I was talking to you earlier about. So someone that you appoint to kind of back you up, to kind of step in once you're no longer here. That person, that successor trustee, simply transfers ownership to the beneficiaries you named in the trust. In many cases, the whole process takes only a few weeks, and there are usually no lawyers or court fees to pay. So when all the property has been transferred to the beneficiaries, the living trust ceases to exist. So from a legal standpoint, it's gone. The trust just vanishes, gets dissolved. Let's talk now about, so we've talked about what a living trust is, how do living trusts avoid probate. Now let's talk about the third question here. How much does a living trust cost? Let's say you are currently in your 30s. It doesn't really matter. The age doesn't matter here. Whether you have asset or not, a living trust, of course, you got to put some asset in the trust, but you don't have to be wealthy to create a living trust. So assume you decide you want a revocable living trust. How much should you pay? If you want to do it yourself, it'll probably cost you around $50. And there are several ways to do this. You can actually buy a book. You can actually get a living trust program. There is software available there to kind of do that. And that's if your needs are sort of simple. If you want to have a simple living trust, then expect to spend somewhere around $50 to $70. Actually, even on the internet, there are templates. There are living trust templates you can use to create a simple living trust. Now, if you are on the high end of the spectrum here, let's say you have specific needs, or your life is your financial affairs are a little complex and you have the budget for it, I would advise you to hire a lawyer. And a trust lawyer will probably charge you somewhere between $1,500 to $2,000. Again, it depends on the complexity of your financial affairs or your legal affairs. All right, so expect to pay somewhere between $1,500 to $2,500. Now, you may be thinking that $1,000 or $2,000 is a lot of cash, but think about this. We're talking here about your life. We're talking about your life after your death. Think about it. Your life after your death. In other words, your assets will live on. Your property will live on. So you want to hire someone who has expertise, somebody who understands the subtleties of trust, will, and estate planning in your particular state. And you want to receive good value. So it is actually worth it. You get what you pay for, right? Everybody says that. If you're willing to invest a couple of hours of your time using a top quality do-it-yourself resource, you can also get a good result. But it's all about opportunity cost. Do you have the time to do it yourself, or would you rather outsource it? So a basic living trust is not, as I said earlier, is not much more complicated than a will. And you probably wouldn't need to hire a lawyer if, again, your needs are kind of simple. So if you have a good self-help book or software program, you can create a valid declaration of trust yourself. Now, what is the declaration of trust? This is the document that creates the trust in the first place. Right? So you can go that route. You can go the DIY route, trying to do things yourself. And if you run into questions that the software can't answer, then you can reach out to an attorney. So making a living trust for yourself does require some crucial paperwork, and we have actually finished another program on the subject, so you might want to double check that. Right? Exactly. For example, let me give you an example. Let's say you want to transfer what I call a big ticket item into the trust, a house, for example. If you want to leave your house through the trust, you need to sign a new deed showing that you now own the house as trustee of your living trust. This is the kind of paperwork that can be tedious, but the hassles are fewer these days because living trusts have become so common. Remember, even if you still owe money on the house, let's say you're still paying mortgage, you can still transfer the deed into the trust. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. How are you doing today? I hope you are doing fantastic. I'm doing marvelous. We're still having a conversation here around all the things you need to know about living trust in 10 questions and answers. If you love the clarity and quality of the content so far, please consider subscribing to our channel and turn on the notification bell so you are informed in real time whenever we drop a new show. And we drop these gems every single day, rain or shine. And please, if you love the content, also like it, share, and comment below. How to make a living trust? This is the question number 4. A lot of people are appalled at the fact that lawyers charge a lot of money for a living trust. But there is a reason why. To understand why those lawyers charge too much for a living trust and why is it safe to do it yourself, you want to know that a living trust is about as easy to prepare as a will. So you can draft a standard living trust, which is what most attorneys offer, and you start with a lot of legal, I would say, boilerplate language, and you can add the following information. So add the name of the person creating the trust, and this person is usually called the grantor, the trustor, or the settlor. Grantor, settlor, or trustor. So if this is your trust, that's you. So you are the trust maker. You also want to add the name of the person who will manage the trust. In this case, the trustee. Again, if this is your trust, this is you. Think about it. You got it right. The same person creates the trust and controls it. So you are the trustor and the trustee. Third, you need to add the name of the person who will take over as trustee and distribute property in the trust when the trustor dies or becomes incapacitated. This is what we call the successor trustee, the backup trustee, right? So most people choose a spouse, a grown child, or close friend. Some people even choose organizations such as charities, philanthropies, universities to kind of handle that. You need to add the names of the people who will receive the property in the trust. Those are your beneficiaries, just as with a will. And then the name of a person to manage any property left to young beneficiaries. In the past, courts have become involved in the trust process. So they can, the courts can appoint a conservator or a guardian. So after the trust is drawn up, you sign it in front of a notary public. If you want to make the trust effective, all property to be distributed under its terms must be transferred into the name of the trust using a deed or other standard transfer document. So this is the place where, as I was saying earlier, if your financial situation or your legal situation is a little convoluted, you want to reach out to an attorney to help you do the whole thing, because estate planning can be an especially thorny issue when it comes to estate distribution, when it comes to probate, when it comes to will, when it comes to trusts. Now let's talk about what you should make a living trust. This is question number 5. The big advantage to making a living trust is that property left through the trust doesn't have to go through probate court, right? I've said that time and again. The primary goal here is to avoid probate. In a nutshell, probate is the court supervised process of paying your debts and distributing your property to the people who inherit it. The average probate can drag on for months before the inheritors get anything, and by that time there's less for them to get. In many cases, about 5% or 10% of the property has been eaten up by lawyer and court fees. So you're not working hard right now to pay probate lawyers later on or probate courts later on. Your goal is to pass on the wealth, pass on your hard-earned money and property and assets to your heirs, those who matter to you. Now, not everybody has to worry about probate, and not everybody needs to even create a living trust. Again, it depends on your situation, it depends on your needs, it depends on your goals, it depends on the sort of financial platform you're dealing with, your financial wealth, your wealth. Now, is a living trust document ever made public like a will? Remember, a will is always made public, but is a living trust document going through the same process? The answer is no. A will becomes a matter of public record when it is submitted to a probate court, as do all the other documents associated with probate. Inventories of the deceased person's assets and debts, for example. The terms of a living trust, however, need not be made public. So it's up to you to really know what you are looking for, and you don't have to worry about putting some stuff in the living trust and being scared about those things being publicized in the future after you're gone, because they will never be publicized. And this standard is analogous. It is consistent across all 50 states and Canada. So this is something to take into account and be comfortable with, and knowing that as long as you have the right setup, the right legal setup, the name of the you have the grantor, the trustee, the beneficiary, the successor trustee, and the name of a person to manage any property left to young beneficiaries, in this case the conservator or the guardian, you should be fine. Of course, those 5 people, those 5 or 3 or 4, depending upon the setup you have, will know about the trust, will know about the contents of your living trust, but not the public. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. How you doing? We're still having a conversation today around living trust, and I hope that this show, this conversation, this talk is bringing value to your life. You are understanding things gradually, how important a living trust is. Let's go to question number 7. But before I do this, if you love the content's clarity and quality so far, please consider subscribing to our channel right now, and turn on the notification bell so you are informed in real time whenever we drop a new show. And we do this every single day. Question number 7. Does a living trust protect property from creditors? The short answer is no. The long, convoluted answer is it depends. But let's just keep it simple here. No. So a creditor who wins a lawsuit against you can go after the trust property just as if you still own it in your own name, right? This would have been too easy if people were allowed to shield their assets into a trust and committed mischief and not paying for their mistakes. So no, a living trust does not protect property from creditors. Generally, after your death, all property you owned, including assets held in a living trust, is subject to your lawful debts. Let's say, for example, if your house is held in a trust and passes on to your children at your death, a creditor could demand that they pay the debt up to the value of the house. Ownership of real estate is always a matter of public record. We know that. You can go to your city, to your townships, real estate records, and people can see this. So creditors can always find who inherited real estate. This can be more complicated for creditors to know who inherits other property, however, because as I said earlier, a trust document, unlike a will, is not a matter of public record. So lenders may not bother tracking it down. They will not track down your stock, bonds, ETFs, valuables, commodities that you pass on to your heirs. But they can for real estate. Probate can also offer a kind of protection from creditors, because during probate, known creditors must be notified of the death and given a chance to file claims. If they miss the deadline to file, they are out of luck, and this is forever. Question number 8. Remember, folks, we're talking here about 10 questions and answers you need to know about living trust. And I've already talked about 7 questions. And let's move on to question number 8. If you make a living trust, do you still need a will? Yes, you do. And let me break it down for you. A will is a primary backup device for property that you don't transfer to yourself as trustee. For example, let's say you acquire property shortly before you die, 6 months before you die. You may not think to transfer ownership of it to your trust, which means that it will not pass under the terms of the trust document. But in your will, you can include a clause that names someone to get all the property that you haven't left to a public's beneficiary in the trust document. If you don't have a will, any property that is not transferred by your living trust or other probate avoidance device, such as joint tenancy, we have another show on joint tenancy. So any property that is not transferred by a living trust will go to your closest relatives in any order determined by state law. So these laws may not distribute property in the way you would have chosen. Remember, the state is not bothered with personal preferences. They have the probate process there, and their goal is to be as fair to heirs and society in general as possible. So this is why it's important to have a will. It's important to clarify things so that legislators can honor your wishes after you're gone when it comes to transferring property from your personal portfolio into your heirs' portfolios. Let's now talk about whether or not a living trust can reduce estate taxes. And the answer is no. A simple probate avoidance living trust has no effect on state or federal estate taxes. Again, this would have been very easy if authorities had allowed that, right? People would be creating living trusts here and there in an attempt to evade their fiscal responsibilities, which is not the goal here. Keep in mind, for debts in 2020, only estates worth more than $11.58 million will owe federal estate taxes. This means that very few people have to worry about this tax. This exemption amount will increase with inflation. The numbers changes every year. The IRS and Congress change the number every year, and but for 2020 the number was $11.58 million. In the past, trusts were used to help couples save on estate tax. However, the large personal exemption and portability for spouses make AB trust largely unnecessary. The last question here in today's show is, does your living trust need an EIN? What is EIN? EIN stands for Employer Identification Number. It's also, sometimes people talk about TIN, Tax Identification Number. So a revocable living trust does not normally need its own EIN while the grantor is still alive. So if you are the trust maker, the grantor, the trustor, if you're still alive, then your trust does not need an EIN, because during your life, the trust is revocable and taxes are paid by the grantor as an individual using the grantor's social security number. In other words, when an institution requests an social security number or EIN for a trust property, the grantor just uses his or her own social security number. When the grantor dies, the living trust becomes irrevocable, and the successor trustee will get an EIN from the IRS to pay the trust's taxes. For shared property, though, and that's kind of essential, folks, if you have shared property in shared living trust, the grantors can use either person's social security number. So when choosing which social security number to use, keep in mind that income on trust property will be reported through the social you select. This won't matter to couples who file taxes jointly. So if you or your spouse you file a joint tax return, that's pretty cool, because then the taxes that one person will pay, the taxes that the trust will pay, will be paid by the couple. But this could make a difference to couples who file taxes with separate returns. So if you are married filing separate tax returns, this can be a little complicated. So for individually owned property in a shared living trust, always use the owner's social. Okay, folks, this is the end of today's conversation. I really appreciate your attention here. I just want to quickly recap. So I was giving you a primer on living trust. All you need to know in 10 questions and answers. Here are the 10 questions. What is a living trust? How do living trusts avoid probate? How much does a living trust cost? How to make a living trust? Why should you make a living trust? Is a living trust document ever made public like a will? Does a living trust protect property from creditors? If you make a living trust, do you still need a will? Can a living trust reduce estate taxes? And the last but not the least question, does your living trust need an EIN, an employer identification number? Thanks, folks, for today's conversation, for your attention. I really appreciate it. Until next time, remember, stay marvelous.